All right, Representative Mincey. All right, on your bill, sir.
Good morning, Chairman Gaines. It's an honor for me to be here this morning, and I want to thank you personally for working with me to allow me to be here today. I also want to apologize for having to bring this legislation in front of the committee just because of the sensitivity of nature of it. It's deplorable that we even have to have these type of discussions. But I'm here to present HB 136 to you. HB 136 creates the crime of adulterating a food product, provides elements of the offense, provides a definition, and provides criminal penalties. Now, I know we got a lot of esteemed attorneys up here, and I'm not one of them, so I can't really speak on behalf of current statutes or prosecution. But I have vetted this as much as I possibly could. I've talked to attorneys, I've talked to judges, my district attorney, and I've actually reached out to the Attorney General Jeff Landry's office. And I have Matthew Derby's with him today to answer any of those questions, but they're here in support of and to assist me with this bill. So I'll forward it and turn it over to the committee for any questions from me, or we can ask Mr. Derby to come up here.
All right, we have green cards in support. Matthew Dexter with the Department of Justice, Kevin Hughes, Chief of Police. Does not wish to speak, just here for information purposes, Chief of Police Association. Yeah. So, you wish to give testimony on the bill?
Yes. My name is Matthew Durbus with the Attorney General's Office. I'm the Deputy Director of the Criminal Division. I've been in that position for a couple of years now. I've been a prosecutor for about 15 years now, primarily working out of the Attorney General's Office, and before that, I was an Assistant District Attorney in Orleans. I appreciate the opportunity to speak on this bill, in favor of this bill, and I'm happy to answer any questions you may have.
Any questions by members of the committee? Representative Marino.
I was just trying to figure out procedurally why we're doing the criminal case in civil law. I mean, in judiciary, not in criminal justice.
Yeah, I can answer that question. Just because of the logistics of what we're going through in session right now, it was inadvertently omitted, just overlooked. And I spoke to the chairman about, I did everything I could up front to have it scheduled, and it was just accidentally left off. And once that was determined, I tried to see what I could do to try to get it heard in the House, obviously before we send it to the Senate. And was speaking with our staff and Chairman Gaines. We got it here. So.
Okay, so with the Attorney General's office, is there any other? This creates a. It's a felony. Sorry. It's a felony offense, carrying up to 5 years of both. Is this? I'm just trying to think because I didn't look to see. Are there any other similar crimes to this that this is related to, or is this not a crime at all right now?
There's another statute on the book, 14:38.1. This proposed legislation is 1438.11. So the one on the books right now, it's been there since 2014 in its current form, is mingling harmful substances is the title. And the difference between 1438.1 and this proposed legislation is that under existing law, the state would be required to prove that someone put something that is, quote, a harmful substance into a food product. Also, it adds the extra element of having to prove that the person take it to be injured, that I would have to put something in a food product to cause injury versus a situation where I believed it was actually helping the person. And so this new law says, look, there's not that requirement. It's merely the requirement that the person take it without their knowledge or consent. It also kind of goes on. It doesn't.
Let me interrupt you so I can keep up with you. So 1438.1 requires an injury.
No, it doesn't require an injury. It requires that the person or the defendant intend to cause injury.
Okay,
in the substance.
All right, and that's a up to 2 years offense.
Yes, sir.
I'm just trying to, because whenever we put in or whenever we're adding or changing or criminal offenses, I always just try to. What I'm looking to see is if we're in line. If we're not, if we're putting things in line, and not putting outliers on fines or penalties or anything. So why do we want to go from a 2-year fine on the mingling harmful substances to, I mean, a 2-year maximum penalty on mingling harmful substances to a 5-year penalty on this? Just
I can respond to that. So we had, during the development of the potential legislation, we had those discussions, and we discussed the existing, and just because of the nature of the offense, we decided to go ahead and put the 5 years in, and that just gives our judges, judicial system, just an extra, I guess, an extension, if they think it's relevant. But it would be up to, obviously up to the prosecution of it.
okay.
I mean, if this happened to me, 5 years is not enough. If it happened to my kids, 5 years is not enough. And I understand we've got guidelines to follow through, but I think it's appropriate.
Representative, but let me say, I agreed to hear the bill as a courtesy to you because I understand the way you explained it, you would not be given an opportunity to hear the bill, but criminal justice will be meeting again, and I do have some qualms about whether or not the bill is appropriate before the committee, given the fact that criminal justice will be meeting again. So if there is opportunity for this to be heard in criminal justice.
Well, I'll just say that in speaking with staff, they thought it was appropriate that they could be sent here, and my concern is just because of the limitations that we have with everything with the COVID, we're about to run out of time from the Senate side. So that whenever I was told it was okay to bring it here, then we moved.
Well, I understand, but there is additional time and there's an opportunity to be presented before the proper committee based on my assessment of the timelines. But anyway, Representative Edmonds.
Did you call on me, sir?
No, I'm sorry. Yeah, go ahead, Johnson.
Yeah, I just want to make sure I understand. So the Attorney General's office is actually supporting this bill.
Yes.
Believes it makes it more, it makes it more plausible to be able to prosecute without the intent requirements.
It removes some of the challenges that the current law has. Yes, sir. We support it.
All right. Did you have any problem with the difference in the penalties between the two? 38?
Personally, I think the 2 years that's on the books right now is probably a little too low.
Okay.
I'm not a representative.
Maybe next year we raise that up. All right. At the appropriate time, I understand this is an unusual situation, but I think we're all in unusual times. If at the appropriate time, I'd like to move favorable passage.
Thank you. Appreciate it. Representative Edmondson.
Thank you, Mr. Chair. For the purpose of the public and the people that are watching that might not understand where this came from, you can either answer or you can answer whoever is the appropriate person. But could you give us that information?
Yes, Rep. Emerson, I appreciate you inquiring on that, and if I may just say that this is extremely sensitive, and if you can imagine that if anyone who would be in this situation is extremely sensitive, and I would like to not give any credit to the circumstances that led to this, but if you're insistent, I can, but I'd prefer not to be quite honest.
Okay, can you give the public a little bit more information than what they have without disclosing things that you don't want to do? Because I'm thinking that there will be a lot of people that don't have any clue what we're talking about.
Yes, ma'am. Well, I think the intent of the legislation speaks for itself, and the testimony that I think we've had should be adequate for the public. And again, if you want me to give you specifics, I can.
I don't want you to be uncomfortable at all, Representative Mincey.
It's not about me, ma'am. It's just about the people who may have possibly been affected by it.
Okay, so this has occurred in Louisiana?
Well, regardless
across the country?
Regardless of whether it's occurred or not, I think it's appropriate to have this legislation in place to be able to respond to when it does happen.
I understand. Okay. Thank you very much.
Thank you for your question. And if I just may, Representative Johnson, just to follow up, the Attorney General's office, I've been in constant contact with them through the development of this, and they supported it from the beginning, supported the 5 years, and have been extremely supportive of this legislation. So just to thank you.
All right, thank you. Representative Stefanski?
Thank you, Mr. Chairman. And Representative Mincey, you and I talked about this before. I don't like the fact that we're hearing this in judiciary, but I understand it's a time situation, and we can debate that issue on the floor as well if it moves forward. I would prefer to see this bill, tucked under 1438.1 if there's an ability to do that, and I'm happy to work with you from here to the floor on that if we have that ability. We worked so hard to clean up the criminal code a couple years ago in Chairman Mack's committee, and I'm very hesitant to create new crimes, but I do understand what you're trying to do. Horrible story that came out of your area, and I appreciate what you're trying to do. Just let's try to work from here to the floor on seeing if we can't clean it up and fit it under something else, if you don't mind.
Yes, and Representative Stefanski, thank you for bringing that to my attention today. And as I told you earlier, I was not aware that situation even exists. Whenever I asked staff to help me present this and working with everyone, that's led us to this today. I have no objection if we can tuck it in somewhere, as long as it doesn't defeat the purpose of trying to get this in the books for this year. So
Yeah.
if we can tuck it somewhere and it works, and it makes everybody happy as far as logistically and and procedurally, I'm okay with it. But if not, I hope that we can pass this so we have something there.
I understand. All right. Thank you, Mr. Chairman.
Question by Representative Landry.
Yeah, a couple quick questions. I was just a little concerned, similar to Rep. Edmondson, but I think John answered it. I was going to ask, is this something that has been threatened? Because it seemed like he just said that this actually occurred. I'm just a little confused about whether it was a threat or it actually happened.
If I may, just respond back to the same, that I'd rather not talk about the specifics. But in the event that it occurred or in the event that it hasn't occurred yet, I think the offense is the charges are relevant. Again, if you want me to give you more details, I can.
This is a little unorthodox, to say the least. It sounds like maybe there is an open investigation, and maybe that's the answer to it. I'm also just wondering, just looking at the language of this, it mentions all the human, animal waste, etc., and it uses the word intentional. So how do I want to say this? Meatpacking plants and butchers and that sort of thing. I mean, I don't think some of this can be avoided, but I understand the word is intentional to cover anything that may become a level of a crime versus what happens in a meatpacking plant.
Yeah, you're absolutely correct.
Sorry for the long question.
No, I think the also, and Matthew may be able to expand more, but the actual intention to do it without someone's consent is as well is very relevant.
Could you speak to how this may affect, meatpacking plants or butchers or that sort of thing?
I think with any violation of Title 14, as a prosecutor would file a bill of information, we would be required to prove general criminal intent in this particular case versus somebody accidentally, sweating onto a item of food as they're making a cheeseburger, or someone working in a meatpacking plant getting a bodily substance. There has to be criminal intent to put a substance into food, medicine, or drink with the intent that the other person consume it without their knowledge or consent. So I think there is a requirement that you have mens rea or general criminal intent versus an accidental situation.
If this happened today, would this not just fall under a battery or something like that that already exists in the criminal code?
The challenges we have, as I was saying before, under 1438.1, is that the prosecution will have to prove that the person acted with the intent to cause injury to the recipient of the item, and that the substance was harmful. So let's say a situation where I watch 2 or 3 YouTube videos and I believe that my blood contains antibodies and it is helpful for everybody in this committee to ingest my blood. I go back to the coffee pot and I put a few drops back there. All right, the prosecution, while that behavior is reprehensible, the current law would require the prosecution to prove that my blood is harmful and that I acted with the intent to cause injury. This makes it a little less challenging and would criminalize the behavior that I just mentioned.
That's a good response. Thanks.
Okay. Any further questions by any members of the committee? Representative Johnson has moved to report the bill favorably. Any objections? No objections. Bill is reported favorably. Thank you.
Thank you.
Thank you.